Good morning. Welcome back to the Second District Court of Appeals remote oral argument. I'm not going to call the cases in order listed on the docket, as everyone has already found out. However, I will we'll start back at the beginning of the docket. And the next case is Clinton versus State. And let me remind everyone that when you're called, there'll be a brief pause as you transition to the virtual courtroom. That may be you may have already experienced the pause. I see you there. And after the case is completed, you will be asked to leave the meeting, but you can continue to view online if you wish. Each side is given 20 minutes, and please remember to tell me whether and how much time you'd like to reserve for rebuttal. Let's see, counsel for, Mr. Upson, is there a certain amount of time you'd like to reserve for rebuttal?
Judge, 2 minutes, if I may.
Thank you. Let me adjust your request here. Go ahead, sir.
May it please the court, counsel Keith Upson for appellant Fred Clinton. Good morning. This morning, I'd like to address the first 3 issues briefed in some capacity. So I'm going to try and accomplish that. The good news is I'm going to go in order. These are going to be 1, 2, and 3. The first issue regarding the uncharged prior acts, there are 2 subparts to that I'd like to address this morning. Initially, I want to point out that nowhere in the state's motion do either of the words inextricably or intertwined appear. Now, I've called it throughout a Williams rule motion. I pointed out, I think in the reply brief, there's no such thing as an inextricably intertwined motion. So at times I may continue to refer to it as a Williams rule motion, but I'm specifically talking about the motion I'm sure the court's familiar with at pages 36 through 38 of the record. The state's motion sought relief from the court, but did not put Mr. Clinton on notice of the legal basis for admitting the facts that the state sought to introduce, something that was reflected at the hearing in defense counsel's statement, quote, "They didn't put the statutory basis in the motion," close quote, at 435. The truth is the state didn't put any basis in the motion, and omitting the grounds on which the motion was based constitutes a procedural due process violation. Rule 3190A requires the grounds be contained in the motion, and procedural due process requires fair notice and a real opportunity to be heard, as quoted from this court's 2004 decision, Smith, in, I believe, only the reply, not our initial brief. Here, there was no notice provided to Mr. Clinton of the grounds, the legal basis on which the state's motion was based, and procedural due process violations constitute fundamental error. That's the first of those 2 subparts as to our first issue. The second is that none of that prior conduct, none of that Williams rule evidence was actually necessary for the state to tell their story. They didn't need it to describe the charge acts. They didn't need it to provide an intelligent account of the crimes that were charged. They didn't need it to establish the context for the charged offenses. And they didn't need it to describe the events leading up to the charged offenses for reasons I'll get into in more detail in just a second. But that's really why we have Florida Statute 94042A, is to prevent the state from using those prior uncharged acts. There was an injunction in place, period. The state of Florida tries aggravated stalking in violation of injunction cases every single day just on that. There was an injunction in place, full stop. The standard instruction for aggravated stalking, which was given here, is 3 elements. There was an injunction, defendant knew about it, and the defendant did something or things to violate it. And further, and important in this case, the conduct alleged to constitute the violation has to be charged conduct. It can't be events alleged to have occurred prior. That seems obvious, that it can't be conduct prior to the entry of the injunction that could form the basis for the injunction of the aggravated stalking. But this case presents facts where I feel compelled to point that out. It has to be charged conduct. So none of those 4 factors were present that could have made this prior conduct inextricably intertwined. I understand why the state wanted the jury to hear that stuff, just like I understand why the code and the authority preclude it. So none of that conduct was necessary to describe or provide an intelligent account or establish context or to describe the events leading up to the offenses. In fact, the state is forbidden in circumstances from providing that context, all that prior uncharged conduct. This is, I'll no doubt pronounce it incorrectly, but I'm relying on this court's 2012 case, Raleigh, as to a situation where the state doesn't get into, if it doesn't accomplish any of those 4 things, the state doesn't get to get, it doesn't become inextricably intertwined and the state doesn't get to put it in front of the jury. Curiously, in the commencement of closing argument, and I have this as volume 4 of the transcript, because I think, as I noted, the copy I was working off of, which is off this court's docket, doesn't seem to be sequentially noted. If everybody else got a good copy and I'm the only one referring to multiple volumes 4, and it wasn't even volume 4, if I remember correctly, it's volume 3, but it had been mislabeled volume 4. So I figured, why fight it? Just stick with what it's labeled. But it's at page 21 of what I'm referring to as volume 4. When the state began their closing, they started out on the right track. Quote, "Why did Whitney leave? Why did she decide to leave and never come back? It doesn't matter. It doesn't matter." Close quote. But then just 2 pages later, at page 23, when starting to address the elements of aggravated stalking, the state went right to Missouri. They went right to, "She told you this defendant showed up at the house in Missouri and was banging on the door. She told you he constantly called, texted, emailed, wouldn't stop. Even when she tried to end it amicably, saying, 'I paid the rent for the house. It's all yours. Do it.' The defendant wouldn't stop." To use the state's own words, all that prior stuff, it doesn't matter. The trial court abused its discretion by allowing the state to use all of that uncharged conduct, and the state can't show there's no reasonable possibility that the error contributed to the verdict. Our second issue concerns the instruction on necessity, and the standard here is any evidence. As briefed, so I won't dwell on that too long, the court here used too stringent, too burdensome of a standard. And there was, in fact, evidence that supported the instruction that was given. Citing this court's 2012 case, Williams, a defendant is entitled to have an instruction on his theory of the defense, however flimsy the evidence is, which supports that theory, however weak or improbable his testimony may have been. The law is not if there's evidence that supports each and every element of the defense the defendant wants the jury instructed on.
Mr. Upson, in the colloquy on this instruction, it seemed that the judge was principally concerned with whether there was an imminent danger of Mr. Favre committing an act of molestation on either Will or the baby, assuming the baby was, well, I guess not the baby. But in any event, That's the part of this that I'm struggling with. That it was necessary for your client, he wanted an instruction on necessity because it was the only way he could preclude the imminent danger of Mr. Pfaff molesting the step grandson. Can you address that, please?
Yeah, Judge, simply, and it tracks consistent with my argument. It's a jury decision because it's clear that this trial judge struggled as well. And
this is an abuse of discretion standard.
That's correct, Judge.
Okay, I'm sorry.
What the trial judge really was struggling with was where is there really any basis to claim that this was a necessity? It was a conversation that had happened way back. She had recanted. So just the fact that someone is being, has in their mind that something bad could happen when there's really no evidence that there's something imminently going to happen. In that situation, how is that abuse of discretion for the judge not to allow the trial to be refocused onto some facts that haven't been developed at all?
Judge, and I have an answer for that as well. And I think the state touched on that somewhat tangentially in the answer brief at page 30 when Mr. Tannen pointed out that there was no evidence that the danger was real, but that's not an element. That's not what the very first 4 words of the first element of necessity, the defendant reasonably believed.
Well, reasonably. Would perhaps necessitate evidence to support that the belief was reasonable.
And not to cut you off, Judge Atkinson, so I need to make sure you're done, but I got an answer for that one too. You know what creates a reasonable belief that somebody molests children that they're related to in their care? When a significant other says, hey, he molested me as a child.
Which she recanted, according to what she later said.
Kind of hard to unring that bell, though, Judge, is our position.
So assuming that the belief was reasonable, can it be said that all or the majority of the violation of the activities in violation were committed out of necessity to avoid the danger? I mean, the throwing of the flyers and the and stuff could be arguably perceived as in some way trying to protect the potential victims, but just badgering with communication. How does that actually? How is that out of necessity to avoid the purportedly reasonably believed danger?
Well, and again, Judge, that's also why it's a jury decision, because those would be things discussed in closing argument. If you want an instruction, isn't that something that the trial court's allowed to consider? Isn't that something that the party requesting the instruction should have an answer for? In other words, one of the elements for the defense of necessity is that the violation of the injunction must have been out of necessity. And if there is, I'm sure opposing counsel is going to come up with examples that he believes were not even arguably out of necessity. Shouldn't the party requesting the instruction have an argument for why they were all out of necessity? Well, I don't know that this record that we got to hear counsel's argument on that because the instruction wasn't given. And I'm not deliberately dodging your question, though in fact I appreciate that I might be by continuing to harp on the fact that that's why it's a jury. We can do a lot of those things about, well, what about, and was it enough, and how could they find? That's all a merits determination, though. And I think, I don't want to say savvy trial judges, because I don't want to say that this trial judge, in a vacuum then, I think for the most part, when reviewing records and the defense requests an instruction, I think the tendency is you just give the instruction and you let the jury sort it all out. And I think Williams supports that. Any evidence which supports it is pretty broad, that we, by which I mean the court, isn't gonna invade that factual determination that if there's any evidence which could support the theory of the defense, give the instruction, let the jury figure it out. They're the ones sitting there determining all those facts for themselves. So I appreciate, and it's also not often that we get to see, and these were quotes within quotes, and it's all from Williams from 2012. However flimsy, however weak or improbable, I think that's pretty good guidance. However flimsy or weak and improbable, give the instruction. You need to give the instruction. I have completely lost track of my.
Well, I'll redirect you if that's what you're inviting, redirection. You have 4 minutes left in your 18 minutes, and I have a strong feeling that opposing counsel is going to make a case for why the evidence was inextricably intertwined. And I thought, your argument thus far has been that there is they could not possibly have been intertwined in any way. Could you anticipate, having read their brief, what their arguments for inextricably intertwined was and why it lacks merit?
I think they just went with number 4. They need to describe the events leading up to the offense, and they may have thrown in context a couple of times, which is number 3, for good measure. But again, that's exactly why it's prohibited. You try aggravated stalking counts each and every single day on the 3 elements of the count. There wasn't
one of the arguments that I recall to mind, and I may butcher it, but I'll be corrected when opposing counsel gets up here, is that the putting in fear, in other words, that they created a credible belief in one of the victims' minds, at least, that there was a danger based on prior contact. That's why I wanted you to have an opportunity to respond. And again, I may be butchering that argument, but that's the gist. Is that something necessary for the crime?
No, it's not. And again, I understand why they would want to. Boy, he's really a monster. It's not just everything he did after Florida and the injunction, but let me tell you about all that stuff before, which kind of segues into the third point I wanted to get into, but probably can't, which is the
doesn't stalking ever turn on the state of mind of a reasonable person being allegedly stalked?
Judge, the phrase I'm trying really hard not to say is that the state likely had sufficient facts that occurred after entry of the injunction to have filed this charge and to have argued to the jury how he had violated it.
No, that's not the standard, of course.
No, but that's also exactly why the state's forbidden from going through from day one. Oh, this is how many years of an abusive, awful relation. Okay, we get it. She got an injunction because of all those things. Now tell us what happened from that day forward. Make your case from that day forward. Otherwise, we would have an exception that says in all violation of injunction cases.
But in this situation, it was just served, correct? I mean, this is all kind of still happening. He's come down from up north. It's kind of in progress as opposed to what you just described, where there's a break in action. There was an injunction, some time went by, and then this started up again.
Well,
correct?
I'm not sure.
Isn't that a difference between what you just described?
I'm not sure if I misspoke, but when I talk about the 2018 allegations and the Missouri allegations, those are the ones that never should have come in because of that reason, Judge, because they were too far removed from the facts and circumstances that gave rise to this injunction and these charges.
The injunction was just being served, is my point, right? So this is something that's
fairly contemporaneous, but they had a lot of material. The state had a lot of material here to work with without going back to 2018. And I have absolutely no time left to talk about the closing argument whatsoever.
You have 25 seconds if you want to keep your 2 minutes.
See if I can do this in a minute and a half, and in my 30 seconds, just thank you, if the court would permit me. The good news is that closing was impermissible for all the reasons we already said. I'm comfortable with a bright line rule that doesn't yet exist that says repeatedly referring to counsel by name is not ever okay, period. But even if arguendo, even if we throw out the initial denigration objection, which was sustained because counsel didn't then move for a curative or a mistrial, You've still got everything else after that was improper, including the continued denigration, which raises some interesting legal questions about, does counsel have to continue objecting over and over when in closing argument, fundamental error can exist where counsel never objected at all? Specifically, the emails. We wanted to give you the whole picture because there are so many emails. We only gave you part of it at page 68. The state can't argue in closing, we only gave you some of the incriminating evidence that exists that supports our burden of proof, but take our word for it, there's a lot more incriminating evidence you haven't seen. You can't do that. It's Warmington, the Florida Supreme Court, 2014. You can't ask the jury to convict for any reason other than having met your burden, which is also why the send a message argument failed. That time counsel was overruled.
You're about down to a minute, counsel. I just wanted to let you know. Sorry to interrupt your thought.
Thank you, Judge. I'm going to get to say Baruti, which I'm probably pronouncing wrong as well, from 2020. This court at footnote 2 reiterated there's no need to move for a mistrial or ask for a curative instruction. It would be moot if you object and you get overruled. Those issues were preserved. It was error for the court to permit the state to continue attacking defense counsel, denigrating the defense, arguing for the jury to convict for reasons outside having met their burden. And they were fundamental. The state's closing as a whole was such a mess. Nothing could have fixed it. And we can't say from the record with any certainty the jury could have reached their verdicts without the state's impermissible argument. And we ask that the judgments and sentences be vacated in this manner, be remanded for a new trial.
Thank you. Counsel for the state.
Good morning, Your Honors. May it please the court, my name is Jonathan Tannen with the Attorney General's Office representing the state of Florida, and the state is requesting that the judgment and sentence be affirmed. The first issue is the admission of collateral act evidence. The trial court did correctly admit this evidence on the grounds that it was inextricably intertwined with the charged offenses and was necessary to provide context for the crimes and to show the events leading up to the crimes, which the Florida Supreme Court has said is a permissible basis for such evidence to be admitted. The case here involved a continuing series of events that began when Ms. Schultz, the victim, broke up with the defendant, Mr. Clinton. She left him and went to stay at her parents' house in Missouri. And the facts were that he immediately began to harass her. He sent her emails constantly and text messages. He showed up at her house, screaming outside.
We know it's a continuous series of events, nucleus of activities, whatever you want to say it. But counsel for the defendant made a point that has some resonance for people like you and me and him and he who deal with injunctions, isn't that always going to be the case? I mean, there was an injunction entered, and that it just goes without saying that there was activity warning that injunction, and then the case is made about what happened after the injunction and why is it necessary for context? Why is it necessary to adequately decide the deed? The deed is not what happened before the injunction. The deed is what happened after.
Right. Well, the elements aren't just the violation of the injunction, Your Honor. Mr. Clinton was charged with aggravated stalking, which required proof that he knowingly, willfully, maliciously, and repeatedly followed, harassed, or cyberstalked the victims. The fact of
so just to clarify though, in the information, did you charged that time period that didn't include the Missouri activity, correctly? Correct?
That's correct, Your Honor. The time
period was
period,
aggravated stalking that was charged all the way going back to the time period.
That's correct, Your Honor. The information was charged based on the events that were committed in Florida after Ms. Schultz moved back to Pinellas County with her parents. But the fact that he had been harassing them before the injunction was entered, that he was angry about the breakup, that she obtained the injunction, and that he then continued harassing her, shows that his harassment was knowing, willful, and malicious, the things that are required for proof of aggravated stalking. It was necessary for the jury to hear that evidence in order to understand the context of the case and to understand Mr. Clinton's motivations and his mental intent in committing those offenses. It wasn't just that an injunction was entered and he became angry because of the injunction. It was that he was angry because she left him and he was trying to hurt her and to hurt her parents by harassing them in this way. And what the Florida Supreme Court has said is that evidence that is inextricably intertwined with the charged offenses is admissible under section 90.402 because it is a relevant and inseparable part of the act which is an issue. It is necessary to admit the evidence to adequately describe the deed. I'm quoting from Gozeminski versus State, which is cited in the answer brief. And the Florida Supreme Court has further stated, to prove its case, the state is entitled to present evidence which paints an accurate picture of the events surrounding the crimes charged. Accordingly, evidence of uncharged misconduct is relevant when its admission is necessary to adequately describe the events leading up to the commission of the charged offense. And that's what we have here. The evidence that was admitted was not about his abusive behavior or any crimes he committed before the breakup or in years past. It was his behavior immediately after the breakup that he began harassing her, that she obtained the injunction, and that he then continued harassing her. It was permissible for the state to introduce that evidence so that the jury could understand the facts of the case.
Mr. Tannen, I think I understand your context argument, which essentially is this is one series of events that pertain to the same event and culminated in the injunction and so on and so forth, correct? The context around
Correct. That. Yes, Your Honor.
I'm going to ask you to shift to a different point. Your opponent didn't get a chance to talk about it, but it was briefed, which is the fourth issue, and this just segues a little bit. Could you address your opponent's argument that there's a double jeopardy problem here with the violations?
Yes, Your Honor. There was no double jeopardy violation in this case. The test under Blockberger versus State is whether each offense contains an element that the other offense does not. And the Florida Supreme Court addressed essentially this exact situation in State versus Johnson, which is cited.
So your position is that this case, Johnson controls, and I'd like you just to address why our decision in Eichelberger is distinguishable.
Sure, Your Honor. Well, Eichelberger, if I'm pronouncing that correctly, involved a case where the defendant was charged with 3 counts of aggravated stalking that were all committed over the same time period. And what this court held was that because the 3 counts were charged in a single time period and all involved the same elements, they were the same offense, that the evidence that was submitted only supported one conviction. It couldn't support all 3 based on a single continuous episode of aggravated stalking that was committed in one time period. This case involves the defendant being charged with 2 different offenses. One is aggravated stalking while after an injunction for protection against domestic violence was entered. And then the second count is violation of the injunction by going to or being within 500 feet of Ms. Schultz's residence. Count 3 did not require proof that the defendant knowingly, willfully, maliciously harassed and cyberstalked the victims, which was an element of count 1. And count 1 did not require proof that the defendant went within 500 feet of the victim's residence, which was an element of count 3. And so and that was essentially the same situation addressed by the Florida Supreme Court in Johnson, where the second charge was contempt for violating the injunction, but the elements were the same. So under these circumstances, since the offenses have different elements and don't overlap, there was no violation of double jeopardy.
Thank you.
I would just briefly address the argument regarding the pretrial notice that was submitted. The fact that the notice didn't say the basis for the admission of the elements really isn't relevant here. The prosecutor immediately said at the beginning of the hearing that the basis for submission of the evidence was that it was inextricably intertwined. There was argument on that issue. The trial court admitted it on that basis. The hearing on that, the admission of that evidence was held on July 23rd of 2019, and the trial didn't start until August 6th of 2019. So the assertion that there was some sort of procedural due process issue here because the defense wasn't placed on notice is just not supported by the record. Additionally, procedural due process wasn't raised as an issue in the initial brief. So that issue would be waived to begin with, but the record doesn't support that argument. With respect to issue 2, the necessity instruction, the trial court correctly determined that there was not a sufficient evidentiary basis to give that instruction. In order for a necessity defense to apply, the defendant has to have reasonably believed that his action was necessary to avoid an imminent threat of danger or serious bodily harm or injury to himself or others. And one of the elements is that the threatened harm must have been real, imminent, and impending. Here, there was no evidence of any real danger that would have justified Mr. Clinton's actions. His supposed basis for believing that Mr. Pfaff had molested Ms. Schultz in the past was that, according to her testimony, when they first started dating, she wasn't talking to her parents, and he didn't understand why, and he assumed that she had been molested by her stepfather and kept badgering her about it until, according to her, she finally gave in and said, yeah, okay, that happened. And she said within a few days, she corrected him and withdrew it and said, no, that never actually happened. So first of all, there was no evidence that this was actually a real event that had occurred in the past. We also know that Mr. Clinton didn't actually believe that her father was a child molester because he wrote in the emails that he knew the accusation wasn't true. He said, I know he didn't do it, but I know what hurts him, is what he wrote in one of the emails. Additionally, even if he had legitimately believed that Mr. Pfaff had molested Ms. Schultz in the past, that is not sufficient to establish that there is an imminent and impending threat of harm, which means an immediate harm that's about to take place. At best, even if he had legitimately believed that, he was concerned about some speculative future harm, the possibility that Mr. Pfaff might molest Ms. Schultz or might molest her son in the future, not that there was an imminent harm that was about to take place, which is an element of the offense. I would additionally argue that the actions taken have to have been, it has to have been the case that the defendant had no reasonable means to avoid the danger except by committing the offenses. These were not reasonable means under any stretch of the word or any definition of that term. He sent continuous threatening and harassing emails to Ms. Schultz, many of which had absolutely nothing to do with the accusation of molestation. Some of them simply insulted her and called her names. The flyers that he distributed outside of the parents' house and put up throughout the neighborhood, and the signs he put up throughout the neighborhood were certainly not reasonably calculated to avoid a danger. He posted things like, Stephen loves kids, kill Steve. Stephen molested his pregnant daughter and still has sex with her. You will be a prison bitch. Get off your daughter. Is your dad the dad of your baby? These are not things that are designed to protect Ms. Schultz. This was part of the same campaign of harassment. And the trial court correctly determined that there was no evidence that supported the elements of a necessity instruction. With respect to the third issue, the state's rebuttal, most of the arguments that are raised here are not preserved because they were either unobjected to below or because the objection was sustained and no further relief was requested. Just to go through each of the items that are raised in the in the initial brief, the state attorney first said in rebuttal that he would address a few, the term he used was egregious misstatements of law and fact. He was cut off by an objection. The trial court sustained the objection, and no further relief was requested. So under these circumstances, the issue is not preserved, rather. And with respect to that statement, it does not rise to the level of fundamental error. It was a very brief comment that was immediately cut off by an objection. The second is the state attorney's statement that he would respond to the defense's assertion that Ms. Schultz was a liar of the lowest form. There was no objection to that point, so the point is unpreserved. Additionally, in context, it was not improper. The defense did say in closing that Ms. Schultz was a liar and she told a lie of the worst kind and that she shouldn't be believed for that reason. And so the statement by the prosecutor was directly in response to arguments that had been made by the defense. As far as the reference to the opposing attorney as Ms. Hill, this was not objected to below, and there's no indication in the record that referring to an attorney by name is improper or denigrating. I believe Mr. Upson referred to me by name during his argument. I did not find that denigrating. I don't think any attorney would reasonably find that denigrating unless it's made in some way that's sarcastic or something like that. And we have no indication that there was anything like that in this record. With respect to the prosecutor's reference to the fact that not all of the emails were presented, again, this was unobjected to below, so it's not preserved. Additionally, Ms. Schultz did say that the emails that were submitted into evidence were not all of the emails she received. She testified that at one point she was receiving 40 to 50 text messages or emails a day from the defendant. And that was in her testimony. So that was consistent with what Ms. Schultz had testified to. I don't believe the other two statements were addressed, but just with respect to the statement that the injunction was only a piece of paper to Mr. Clinton, there was an objection to that statement, and that objection was correctly overruled. The trial judge determined in context that was not a send a message argument, that was asking the jury to convict Mr. Clinton because he had committed the offense as charged by ignoring and violating the injunction. And that was also consistent with the evidence. Mr. Clinton had written in one of the emails that the restraining order means nothing to him. So that was consistent with the evidence. And additionally, I think the same thing applies to the prosecutor's rhetorical question at the end of the argument as to whether we need to wait for victims to be abused. That statement was made in response to the defense's argument that the jury should find that the elements of aggravated stalking were not met because there was no evidence of any health effects to the victims as a result of the harassment. And the prosecutor correctly pointed out that that was not an element of the offense. There was no requirement of any physical injury. But in response to the rhetorical questions, the defense objected. The trial judge asked the prosecutor to approach and instructed the prosecutor that his argument needed to be to the victim specifically and not to the community in general. And after that instruction, the prosecutor rephrased his argument and said, we don't need to wait for Ms. Schultz to be injured. And no further relief was requested after that instruction. So the state would submit, first of all, that to the extent that the defense wanted any additional relief, the point is unpreserved. But in any event, in context, the trial court did not abuse its discretion in the handling of that objection. If the court has no further questions, I would rely on the state's answer brief for any further arguments and request that the judgment and sentence be affirmed.
Mr. Upson, I'm going to round up to 30 seconds for you to wrap up.
Thank you, Judge. Real quickly, this isn't closing argument. And if you just take the words off the page and reread the closing, every single time the state said Ms. Hill, it was not with love and respect and admiration in the state's heart. And I think that's apparent. I need to use the rest of my time. Counsel said the procedural due process wasn't briefed in the initial brief. That's because we filed a brief based on the record that was actually in front of us, in which we referred to the state's Williams rule motion by the same thing the state referred to it below. procedural due process violation doesn't have anything to do with how many months occurred between that motion hearing and the trial. It's the fact the state filed a motion and had a hearing in which they never told the defense what the legal grounds for the basis of the relief that they ultimately got. And at that point, the bell had been rung. It was the date and time of the hearing. And that is a procedural due process violation that honestly moots whether or not it was inextricably intertwined or not. Defense counsel got notice of the acts they were going to try and introduce, but absolutely no notice whatsoever of the legal basis. So accordingly, defense counsel couldn't prepare for a hearing that the state was prepared to have. That's why it's a procedural due process violation under Smith, this court in 2004. Please vacate his judgments and sentences. And thank you so much, because that was probably more than 30.
It was. Thank you, counsel, and thank you both for elucidating arguments. And we are going to take a break. This completes the argument for this case. And you all can, on the bottom right hand of your screen, push the leave button and still listen in if you'd like online. But the court now will be in recess